Welcome to the Supreme Court. We've been delayed in resuming this hearing because of a problem which one of the counsel, Nigel Jones, Queen's Counsel, is experiencing. Mr. Jones is at the moment in the middle of his submissions. He's going to have to continue simply with audio contact, and we're just going to have to cope as best we can under the circumstances. Mr. Jones.
Lord, thank you very much, and my apologies to everyone for the delays. Lord, may I start with the topic of settlements? Lord Burrows asked me this morning whether there was any jurisprudence in the papers about a settlement, and I made a subsequent reference to paragraph 32 of our written case, which is at page 116 of the bundle. And I wonder if I can invite you just to look at that. So what we've referred there to a recent case of Simon Tobb, and the fact this I think is the closest we can get to assistance at the moment of Lord Burrows' question, and it was held that giving up an argument that a clause to pay $1,000 a day in interest was a penalty clause did constitute good consideration, even though that argument had previously been rejected in an application for summary judgment. And the court, which you will see referred to there, stated that there was a counter-prevailing public policy that must be taken into account in this context, namely the policy in favour of holding people to their commercial bargains. This element of public policy provides a limitation on the public policy discouraging parties from threatening unreasonable claims or defences. And there cannot be any sensible public policy against encouraging parties to raise claims or defences that they reasonably believe may succeed, even if they eventually turn out to fail. So, Lord, the paragraph 33 then refers to Wade and Simeon, which wasn't a case that I had to mind this morning when we spoke. And the cross-reference to that is at 4934. I don't suggest anyone goes to it in the bundle. The cross-reference in the bundle to the quote we've given you from Simon Tobb is at page 2119, 2119. We would respectfully submit that is helpful. I don't know if that goes as far as Lord Burrows was hoping it might this morning, but that's what we had in the written case. May I now move on very quickly to the subject of economic torts? Lord, I should perhaps have said that because we got off to an odd start, I forgot to do so. That in a sense, I'm picking up this afternoon just a handful of miscellaneous points. So there's no thread running between these points at all. Let me just deal with whether we could get assistance from economic torts. An economic torts are there, we submit, to regulate competition between commercial parties. And liability should only attach where a defendant is guilty of carrying out or threatening an unlawful act in the following circumstances. So see your reference, paragraph 71 of our written case, that's at bundle page 129. And we make a cross-reference there to an academic work of Professor Davis and Lord Justice Sales, non-judicially. And the quote from that is at page 6823, 6823. And what they remarked in that article was the point about referring to the unlawfulness of the means used, which may involve a civil wrong committed vis-à-vis someone else, but may not, is that it supplies a ready-made and reasonably accessible criterion, understandable to ordinary people, to demarcate the boundary of acceptable conduct as between claimant and defendant. I simply commend that article, if I may, for subsequent study. Now, there was a suggestion from Mr. Shepherd yesterday that may be the position in the economic torts, that shouldn't apply to contract. And I think he was suggesting it's concerned with voluntary assumed obligation. But if he's right about the rationale behind duress, and the policy concern is to prevent unacceptable conduct, then the same rationale should apply to the law of tort, and with respect, we see no relevant distinction between contract and tort in this regard. So, dealing with a handful of the torts at the moment, intimidation and Rooks and Barnard, and I'm not going to take long on this because this was referred to yesterday. But your lordships may just go to page 4386. 4386, the passage from Lord Reed in Rooks and Barnard. And it's 7 lines up from the bottom of the page, and just, I think, goes over the page as well, in which he says, so long as the defendant only threatens to do what he has a legal right to do, he's on safe ground. At least if there's no conspiracy, he would not be liable to anyone for doing the act, whatever his motive might be, and it would be absurd to make him liable for threatening to do it, but not for doing it. So I agree with Lord Herschel in the reference to the Allen and Flood case that there is a chasm between doing what you have a legal right to do and doing what you have no legal right to do. And there seems to me to be the same chasm between threatening to do what you have a legal right to do and threatening to do what you do not have a legal right to do. So the difference between threats and conduct for our purposes don't matter, but the general sentiment is clear. In the bundle, sticking with that for the moment at page 4452, there is a quote which I'd like to bring your attention to from Lord Pearce. And it begins with the word somewhere. It's about halfway down the page. Somewhere, one must draw the line between pressure or coercion that may be permitted and that which may not. It is logical for the law to say that while a man may threaten to use all the means to which he is strictly entitled by law in order to encompass another's injury deliberately, yet he shall not threaten to use any means to which he is not so entitled. So those are 2 quotations that we commend to the court as being of assistance in suggesting support for the line we submit should exist now between lawful and unlawful duress. The next talk that I should mention very briefly is OBG and Allen causing loss by unlawful means and inducement to breach of contract. Both of those are within OBG and Allen, and as your lordships will know, there are subsequent cases dealing with very much the same thing. But all I'm going to give you, if I may, of these references, it's Lord Hoffman at paragraphs 45 to 64, which begins at 4127. 4127 of the bundle. And obviously the tort of causing loss by unlawful means is pretty clear, and I don't need to say very much more about it. Inducing breach of contract is an interesting one because we find that in speech from Lord Nichols at bundle page 4160, and it's into the reference in the authority for the paragraph is 202. And what that makes clear is that inducing a breach of contract requires knowledge that the contract will be breached, even if you make a mistake. So, so here we have something of a parallel with lawful act duress, because offering someone a contract is in and of itself a lawful activity. It only becomes a lawful activity if doing so could be seen as inducing them to breach another contract. And the answer of in that tort is that it requires knowledge, and mistake won't do. And the reason I've looked out that as an additional reference is I hope to pick up a point that was discussed with Lord Burrows this morning in relation to whether this was going to be, as it were, a charter for people who made mistakes. And we would say there is a confluence between what we're suggesting in this particular arena and what happens in those talks. Lord, the next miscellaneous topic for this afternoon is to give you a couple of references in relation to academic writing. Now, the first comment I wish to make is to do with the article which has been put in the bundle and referred to by Mr. Shepherd yesterday from Dietrich. I think it's Bigwood and Dietrich. First thing to note is that so far as we're concerned, this is neither a published article nor an accepted article. So it may or may not be published in the form in which it's been read to your lordship. But much more importantly, perhaps, is that it's factually wrong when it talks about times travel. So if your lordships would turn that up, it's at page 2841 of your bundle.
Do we know what this, I'm sorry to interrupt you, do we know what this document, what this paper is, if it's not published? Is it, I don't know, is it a paper for some conference or seminar?
It's a paper that's intended or hoped to be published.
Oh, I see.
This is not yet. It's not our paper. It's Mr. Shepherd's. So
Yes.
I'm trying not to be rude or mean about it. But insofar as one would normally include published academic articles, and they would be referred to and so on and so forth, this is not. So I think its current status is, frankly, if I may say so, nothing more than, as it were, an unpublished paper by academics, which has got words in it which Mr. Shepherd would like to reflect as part of his own submissions. And I don't wish to sound churlish, but I wouldn't want your lordships to assume at the moment that it's a published work, because I don't believe it is. If I'm wrong about that, I will give my personal apologies to Mr. Shepherd, and he'll no doubt put me right later in the afternoon. So, Lord,
I'm happy to put them right now, but I'll deal with it later, my lords.
Right.
I'm grateful. So, but in any event, I only mention that because that's what we believe the situation to be. But essentially, it seems to us to be falsely premised. It's wrong, factually. So if your lordships can look at page 2841 of your bundle, which is, I think, page 19 of that, there is a clear reference to the facts, including the proposition that Hayek knew that it had no defence to the claims. You will find exactly the same thing noted at footnote 124, which is, I think, at the bottom of that page. And of course, we all know that is not the finding of fact in this case. It's not the finding of the trial judge, and nowhere could one find support for that proposition in the Court of Appeal Authority. So if we're right about that, that's the substantive point. If and insofar as it includes general text, not to do with times travel, of course, your lordship said, can take anything into account, but it may or may not have resonance for you all. But insofar as it refers to times travel, it appears on the face of it to be wrongly premised. The only other thing I wanted to do was to commend to you, but not take you to now, in particular, two cases. I'm sorry, to take you to two articles. One is Beats and Use and Abuse, and that's referred to in our written case. The reference to that is 6912, and also ADAR at 6525. So generally speaking, when we've referred to academic writings which are referred to in the written case, we would commend them to the court for obvious reasons, and I needn't go over them now. But those two in particular, it seemed to be helpful just to draw your attention to purposes of these last few minutes. So your lordship will be pleased to know that I'm actually doing slightly better than I thought, having cut out taking you to one or two of those references in detail. So I've only got another sheet or so to go. So I think you'll catch up the time that I've caused you all to lose. And I just wanted to bring your attention to two of the non-English cases. Your lordship has scores of them, and I just want to highlight two, if I may. The first is Smith and William Charlick. And I'm afraid I don't have a number, do forgive me. But the facts of this case, if I can just spend a moment talking through them, is this. The plaintiff...
It's, if you give me one moment, we have it at page 2529 of the electronic bundle.
Thank you. 2529. Thank you very much. The facts were these. The plaintiff bought wheat from the Wheat Harvest Board. And after the wheat had been delivered and paid for, the board, even though it claimed no legal right to do so, demanded additional payment, intimating that if it were not forthcoming, it would refuse to supply more wheat. As the board was the sole supplier of wheat in South Australia, the plaintiff paid under protest and then sued to recover the payment on the grounds that it had been made under duress. And we compare that with the following case, with our case. If PIAC had paid TT's claims, but then demanded an equal amount by way of premium from TT to enter into the new agreement, point made by Lord Reid yesterday, there would be no avoidance, and therefore we would be no different from Smith and Charlie. So I just, because of the comment made by Lord Reid yesterday, we thought it helpful to point up the Smith and Charlie decision, because in a sense it feeds into that same point. Mm-hmm. The only other non-English case we would particularly want to draw to your attention is Dold, D-O-L-D, Dold and Murphy. For present purposes, I'm not going to seek to do more than to refer your lordships to what we have set out in the written case, because we've got some quotations from it, and you'll find that at our paragraph 79 on page 132. Let me just, if I may, in the few minutes that I would seek to remain with you, talk you through those two paragraphs. So Dold and Murphy itself, you probably can't have two pages open at the same time, but the cross-reference, let me give you, if you followed me to paragraph 79 of our written case, then the cross-reference to Dold and Murphy is at page 2666 of the bundle. In that case, the defendant held a minority shareholding. The third party made an attractive offer for the company, but at a very late stage the defendant told the other shareholders, including the claimant, that he would only sell his shares if the majority agreed to pay him an additional $5 million Australian dollars from their share of the sale proceeds. Majority shareholders agreed to pay. The New Zealand Court of Appeal held the defendant had driven a hard bargain, but it was not for the court to rewrite the parties' contract. There is a discussion about duress in the judgment. Now, the paragraph numbers are 61 to 80, and I don't propose to walk you through all those paragraphs. You'll find that at page 2684 of the bundle.
You could say, Mr. Jones, it is a very familiar situation of gazumping, or for that matter, in the context of planning the use of ransom strips.
Yes.
So Dold and Murphy, it's a very common fact. It's a very common pattern of facts.
Yes, and your lordship's reference to gazumping is quite interesting, because I dare say that one might find a number of people who would say that gazumping is morally and socially unacceptable, and who knows, one might even find first instance judges around the country who would think the same. But that, we would respectfully submit, is no way to address the principles that need to drive this doctrine. So, Lord, yes, gazumping and ransom strips are both entirely apt example of the sort of thing that this is dealing with. And what the Court of Appeal noted here, and we've given you the relevant quote, is actual instances of lawful act duress are tantalizingly elusive, and the concept appears to reside more in dicta than in practice. Well, whether that's right or wrong is for your lordships obviously to take your own view about, and that's something that we've endeavoured to set out in other parts of the case. The Court of Appeal recognised that the conduct of the defendant was opportunistic but not unlawful, and he was entitled to act in his own self-interest, even if his actions were both unexpected and ungenerous. So one can always use different words to describe different conduct. but I hope that when I walk your lordships through what I would call the basic facts at the beginning of my submissions, or near the beginning of my submission, going right back to 2008 when the first contract was signed, HIAC's ability lawfully to terminate it and not to replace it, its ability to terminate it and offer to replace it on any terms it wished, are simply examples of it acting in its own self-interest. And that may be considered to be harsh by some, but for practical purposes is not relevant. So again, that drives us back to where we started this morning. What is this case really about? It's really about, therefore, following Universe Tankships and Lord's Common. It's about the nature of the demand. It's about following the logic of bifurcation, saying the only circumstances in which this will be upset, this conduct which some don't like will be upset, is if it's accompanied by demand which is not legitimate. So now what we're doing is engaging ourselves into the process of finding out what that expression may mean, and you already have our submissions as to what it means, so far as the Court of Appeal is concerned, that if it means something with a side order of objectivity, we say it shouldn't, but if it does, we'd still win on the facts, and those facts can't be overturned. And that in those circumstances, there is no claim against us for lawful act duress that should be permitted. So, Lord, that's what I wanted to say. I think in the circumstances, I would ordinarily just see if there's anyone on my team that sent me a note so I've missed anything that they thought I was going to deal with, but I don't think I'm going to trouble you as I'm now on the telephone and remote from you. So I'm going to say again my apologies for a final time and hand over a little ahead of time, which I hope allows everyone to catch up. And thank you very much indeed.
Well, thank you, Mr. Jones. I don't think your submissions have lost anything from being delivered in the way they have been. We turn now to the second intervener, Lord Devonshire Trust, represented by Mr. Oliver Jones. Mr. Jones.
Thank you, my lord. I'm going to address a number of topics. The general theme of these submissions is not so much that lawful act duress is inconsistent with certainty, but that it is not coherent with other well-trodden areas of English law. My lords, the first area is the principle of good faith in the English law of contract. And I intend to make 7 short points in relation to this. The aim here, my lords, is to show that the tests for lawful act duress that have been pressed upon your lordships are in essence tests that encapsulate a wider concept of good faith that courts have already held has no place in the pre-contractual bargaining process. My lords, the first point is that there remains no general principle of good faith in English law, and that was a point that was relatively recently affirmed by this court in the Versluit dredging case. I won't take your lordships to it, but it starts at page 4883 of the bundle, and the relevant paragraph is 36 in the speech of Lord Sumption. My lords, the second point is that a duty of good faith does apply, of course, in specific contractual contexts. Now, the obvious example is insurance contracts, as in Versluit dredging, and of course, parties can expressly agree to be bound by an obligation of good faith. My lords, there is then a wider controversy as to when the court will imply a duty of good faith when the parties have not otherwise agreed to one. And my learned friend, Mr. Jones, touched upon this, but it's this particular controversy that has some relevance when looking at the scope of the lawful act duress doctrine as it's been presented to your lordships. Now, I want to go to 3 authorities here. The first is the judgment of Justice Leggett, as his lordship then was in Yam Seng in 2013, which will no doubt be familiar to your lordships. But can I just ask the court to go to page 2641 of the bundle and paragraph 131 of the judgment of His Lordship in Yam Seng. And there His Lordship said that under English law, a duty of good faith is implied into certain types of contract, for example, employment contracts, partnership contracts, or where there are fiduciary obligations, that he doubted whether English law had reached the stage where it was ready to recognise a requirement of good faith implied into all contracts, but His Lordship saw no difficulty in implying an obligation of good faith in accordance with ordinary contractual principles about the implication of terms. And can I just show Your Lordships why His Lordship said that? If one goes over to 2643, there His Lordship holds that an obligation of honesty would be expected by the parties and so can be implied. And at paragraph 138, His Lordship holds that a wider concept of good faith can also be implied. And if I could just pick up the last few lines of that paragraph, Your Lordships will see the reference to conduct which is improper, commercially unacceptable, or unconscionable. And what one sees going through these authorities, and that's the purpose of the analysis, is that these are all terms that are deployed to support a concept of lawful act duress. Out of context there, as I'll go on to show. Over at paragraph 142, His Lordship identifies the separate category of relational contracts, which is important, where more stringent obligations may apply. And at paragraph 144, His Lordship identifies the touchstone of good faith as conduct which would be regarded as commercially unacceptable by reasonable and honest people. And over the page, one can see from the remainder of that paragraph that that articulation is an objective one because it derives from an interpretation of a contractual bargain. My Lords, the second authority I wanted to show you about this is the Court of Appeal's decision in MSC Mediterranean Shipping and Cottonex Anstalt, which is a decision in 2016. And if I could just show Your Lordship one paragraph of that, which is at page 4085 of the bundle. Now, without going through it, Your Lordships, this is a dose of cold water poured upon the approach of His Lordship in terms of implication of a term of good faith in all contracts, and a reaffirmation that there is no general duty of good faith in English contract law. My Lords, the third case that I wanted to take Your Lordships to is Mayan and Kent. Now, Your Lordships have, of course, looked at this case in the context of duress, but in order to see what Lord Justice Legatus, His Lordship then was getting at there, one also needs to look at the paragraphs where he deals with the implied duty of good faith. Now, that's
it's interesting that he cites Royal Brunei Airlines. I mean, that's another equity case, isn't it, about a dishonest agent or trustee, I don't remember which, and constructive trusts.
Yes,
yes. And so he's using the word unconscionable and then citing an equity case as authority.
Yes, my Lord, and as I'll come on to show in a moment, there's a real question when one interprets His Lordship's judgment as to whether His Lordship was really intending to go any further than those equitable concepts in terms of using language of extreme vulnerability or special disadvantage and terms like that.
Yeah.
If I could just show Your Lordship's paragraph 168 of Mayan and Kent, which is at page 695 of the bundles.
Yeah.
Now, this is when one arrives at the current position in English law as regards the obligation of good faith, which is that it is now, I think, relatively settled that one can find such an implied obligation of good faith in relational contracts. And Lord Justice Leggett goes in that paragraph and subsequent paragraphs to show where his reasoning in Yam Seng has been picked up in relation to that specific subcategory. And if I could just, while we're here, show your Lordships 175 on page 697, and down between the letter G and the letter H, this is where his Lordship is again considering the content of the duty, and he says that it is one that identifies conduct which in the relevant context would be regarded as commercially unacceptable by reasonable and honest people. Now, my lords, the third point, having seen that it is only one limited subcategory of contract that contains this implied duty of good faith, on the present state of the law, such a duty is not implied into every contract, and indeed is not implied into the majority garden variety contracts. And what that means, of course, is that in some contractual contexts, the parties are not obliged to act in good faith in relation to each other, even though they have contractually bound themselves to each other. And that is so despite the views of Lord or Justice Leggett, as his Lordship then was in Yam Seng, that all commercial parties expect that they will deal with others in good faith. Now, the fourth point about this, my lords, is that in determining whether or not there is a duty of good faith in a contract, this is entirely consonant and indeed a manifestation of contractual certainty and freedom of contract. It reflects what the parties have agreed. The fifth point is that, consistent with there only being a subset of contracts that have a duty of good faith in it, there is no duty of good faith prior to the contract when two parties who are not bound to each other are negotiating in their own interests. At that prior point, there is no contractual basis for such a duty, and the parties are entitled to agree what they like. And imposing such a duty at this stage would be to detract from freedom of contract rather than to uphold and vindicate the terms of the parties' bargain. And can I just show your Lordships two authorities which no doubt you'll be familiar. The first is Walford and Miles. And if I could just ask your Lordships to go to 2334 of the bundles. Now, the question in that case was whether an agreement to negotiate had sufficient certainty to be binding, but that question then turned upon whether it could be said that that agreement to negotiate was an agreement to negotiate in good faith. And Lord Ackner, with whom Lords Keefe, Gough, Jauncey and Brown-Wilkinson agreed, was definitive in saying that an obligation of good faith was repugnant to the bargaining process where each party is entitled to pursue its own self-interest. So I would commend that page to your Lordships. The other relevant authority here goes to the related principle that there is no duty of fair bargaining in English law, and that is National Westminster Bank and Morgan. And if I could ask your Lordships to go to 1822 of the bundle. My Lords, this was an undue influence case, but the court had to deal with some observations of Lord Denning, the Master of the Rolls, in Lloyd's Bank and Bundy. And one can see their Lordships considering that at the bottom of 1822, next to the letter G, where they note that the Master of the Rolls believed that the doctrine of undue influence could be subsumed under a general principle that English courts will grant relief where there has been inequality of bargaining power. Now, the court notes that the rest of the court didn't agree with the Master of the Rolls or didn't reason on that basis. And then if one turns over to the next page, 1823, and looks at the letter C, Lord Scarman there says, even in the field of contract, I question whether there is any need in the modern law to erect a general principle of relief against inequality of bargaining power. Parliament has undertaken the task, and its legislative task, of enacting such restrictions upon freedom of contract as, in its judgment, are necessary. And at the end of that paragraph, I doubt whether the court should assume the burden of formulating further such restrictions. My Lord, it's trite that in the 30 or 40 years since this decision was made, the legislative field has only become more dense in this area. My Lords, the decision in Walford was expressly referred to by Justice Leggett in Yam Seng at paragraph 122, where his lordship said that that case was entirely consistent with his analysis in Yam Seng because Walford concerns the negotiating stage and the bargaining stage, and not the stage at which the parties had committed to their contractual bargain. Now, it's useful at this point, my Lords, to turn to the test for duress formulated by Lord Justice Leggett in Al Nyan. Now, that is at page 702 of the bundles. Your Lordships have seen it before, but if I could ask your Lordships again to look at paragraph 188, one sees there his Lordship formulating the test for lawful act duress as the defendant has no reasonable grounds for making the demand, and the threat would not be considered by reasonable and honest people to be a proper means of reinforcing the demand. Now, what is immediately apparent from that is that that formulation of the test bears a very close resemblance, if not being identical, to the way in which Lord Justice Leggett has formulated the test for good faith in the context of contract. So if the test in Al Nyan is adopted, what the court is really doing is endorsing an obligation of good faith in the bargaining process that does not even exist in every contractual relationship, number one. Number two, when it does exist, is said to be based on the parties' agreement and in accordance with their bargain. And number three, which would contradict the approach of the court in Walford and Miles, which even in Yam Seng, Lord Leggett said he was not seeking to do. So, my Lords, what appears to be a small and subtle step in paragraph 188 is in fact a giant leap. The shift is made from a requirement emerging from and supporting the parties' bargain and vindicating their freedom of contract to one that is imposed irrespective of the bargain, that undermines freedom of contract and applies during a period, the bargaining period, where these obligations have been traditionally held not to constrain the parties. So that is why that concept of lawful act duress can be jettisoned. My Lords, the sixth point on duress, which arises from these first five propositions, is that when one examines the particular position of contract renegotiation, which is what so many of these cases are concerned with, whether that renegotiation is subject to some obligation of fairness, that is, the parties are not allowed to act in accordance with their naked self-interest, depends critically on whether such an obligation was inherent in their existing bargain. Now, that might be because the law has determined that an obligation of good faith applies there, or because it's a fiduciary relationship. And if there are such obligations, those obligations will impose limits on the parties' conduct in negotiation. And conversely, if there are no such obligations, then ex hypothesi, that is because the law has determined that the contract or relationship imposes no such restriction. And so putting in place new obligations arising from a revised doctrine of lawful act duress is here directly contrary to the lines that the law has already drawn. And that, in fact, is the answer to the APPG's concerns It is not one needs a wider doctrine of lawful act duress. On the APPG's case, one needs to revisit the conclusions that courts have reached, that banker-customer relationships are not fiduciary, that they are not relational, and that they do not contain these types of obligations. My Lords, the seventh and final point on good faith is that if one's... yes, my Lord Burrows.
Just so I've understood that point, might it be said against you that what you have in the situation which we're now dealing with are not two arm's length commercial parties, but we've got effectively a long-term agency and principal type of relationship that might be classed as a relational contract into which you might have already been implying obligations to deal with each other in good faith?
Yes, well, my Lord, that's perfectly consistent with my approach to things. It might not be consistent with the other Mr. Jones's approach to things, because my case is that where one finds these obligations of good faith is the contract, and that is the necessary frame of analysis. And that if one is with me in saying, well, the necessary frame of analysis is the contract, that is where the obligations that condition the parties bargaining come from, then they do not come from the doctrine of lawful act duress. Rather, those obligations are coming from the nature of the parties' bargain, and so they are not needed in the concept of lawful act duress. My Lords, the final point on good faith is simply that if one says that limitations derived from contractual obligations of good faith do not apply in renegotiation, for example, because the contract is not a relational contract, then a fortiori, there's no reason to apply them to the bargaining process, and that would contradict the approach in Walford and Miles. My Lords, that's all I was planning to say about good faith. If I could just
interrupt you a moment, Mr. Jones? Is really just
yes.
pursuing the thought that Lord Burrows had raised with you. When you read this whole passage of Lord Justice Leggett's judgment from 181 to 187, it's all about unconscionability. And what is positing are situations where one party exploits a position of extreme vulnerability, as he puts it, on the part of the other party to impose unreasonable terms on that party. And if one asks, well, how does that fit with NatWest and Morgan or Walford and Miles? The answer, if we're going to be reconciled, may have to be, I mean, really, it's really an answer that reflects the equitable origin of all this, that it's to do with the relationship between, there's a pre-existing relationship between the parties, which is being relied on by, I think, in Lord Justice Leggett's thinking, that if, for example, someone sets up in business as the agent for a monopoly supplier, and they have they invest they're economically completely dependent on the monopoly supplier, and monopoly supplier knows that, then it's obviously going beyond some of the older cases. But the argument would be that you can treat that relationship as one where the standards, the principles of unconscionability, of unconscionable transactions, could apply in the context of a relationship of that kind.
Yes, my Lord, that's right. And they can apply to a relationship of that kind because that's what the parties have agreed on this premise. So it vindicates their bargain rather than undermines it, which is what it does in the Walford and Miles and NatWest examples. The other way in which unconscionability is reconciled with those cases, if you like, is simply by the finely honed and narrow nature of the doctrine. And while we're on the topic, if I could just give your lordships a reference to Snell's Equity at page 3104 of the bundles. The authors there explain the narrow confines of the doctrine of unconscionability and note that it exists within the rubric, if you like, of Walford and Miles and NatWest and Morgan, which is one of the reasons why it needs to be kept narrowly confined, as it has traditionally been narrowly confined.
Yes, and indeed, the language used by Lord Justice Leggett, for example, in 181, he speaks of the defendant exploiting a position of extreme vulnerability to induce the claimant to agree to a wholly unreasonable demand. It's quite restrictive language.
Yeah, yes, my lord, and it almost tracks exactly the three elements of unconscionability that
yes,
my lord identified, I think, earlier today.
Yeah, yeah.
But one further point I would make about unconscionability is that one has to focus on the precise thing that one is doing. So if it is said, well, all lawful act duress is unconscionability, well, there's no need for lawful act duress to do that job because unconscionability does it. If one is saying lawful act duress needs to go beyond unconscionability and evolve in some way, then one is essentially washing away the boundaries of a doctrine that's developed incrementally over hundreds of years.
Well, what may be happening is that one's seeing the doctrine simply extended from its traditional home, if you like, in a framework of personal relationships to encompass certain types of commercial relationship.
Yes, my lord, and if that arises from a contractual relationship that parties have bound themselves to that contain those obligations, then so be it. My lords, if I could just say one thing about compromise, and it links to an alternative explanation for Lord Justice Richard's subjective approach in times travel. Now, the answer to my Lord Burroughs' question about what a bona fide claim in compromise is simply, does one honestly, or rather, does one believe one has a claim or not? And if you know you don't have a claim, then it's not a bona fide claim. And it's not in the bundles, but if I could give your lordships the references to Foskett on compromise, it's paragraph 2-19 and 4-42 that makes that point. And the other point that's made there is that when that occurs, so when someone purports to compromise a claim without having a belief that they do have a claim, that is fraud. That is a fraudulent misrepresentation, and the compromise can be unwound for fraud. So that's the point made at 219 and 442. Now that's exactly the same analysis, and this is the point we made at paragraph 67 of our written case, can be applied to the subjective or lack of good faith belief in entitlement that Lord Justice Richards referred to. So if I know that I don't have an entitlement to be paid for the cigarettes, but I pretend that I do, that's fraud. And so, my lords, there's no need for a sui generis carve-out to be made of some concept of lawful act duress. It's already done by the tort of deceit. My lords, undue influence, can I just say this? My Lord Burroughs rightly pointed out in argument that there are certain cases that have traditionally been considered as undue influence cases that are rightly recategorised into duress. Those are, I think, the three key cases are Williams and Bailey, Mutual Finance and Wetton, and Kaufman and Gerson. The question, of course, then becomes, well, what is the significance of that recategorisation for the purposes of the doctrine of lawful act duress? Does that create a springboard or a beachhead to say that lawful acts are okay or not? Now, my answer to that would be that each of those cases, being a threat to prosecute, is explained by the prohibition on bringing proceedings without reasonable and proper cause, or proceedings that are an abuse of process. Those possibilities are identified by my Lord Burrows in one of my Lord's many textbooks, which is at page 7010 of the bundle, and also by Lord Leggett in Al Nyan at page 212, which is, paragraph 212, which is page 709 of the bundle. And the other point made by my Lord Burrows in that passage is that the other principle engaged here is where a contract may be unlawful as stifling a prosecution. And if I could just give my Lords a reference to Mutual Finance and Wetton, page 1798, because at that point, Justice Porter held that there had to be implied into that contract a term that the son would not be prosecuted, because otherwise the contract didn't make sense. Now, in my submission, once you imply into the contract a term that the son will not be prosecuted, the contract fails as unlawful. So, my Lords, the short point arising out of this is that those three cases, recategorised from undue influence into duress, do not then create a beachhead for the doctrine of lawful act duress. My Lords, in the last couple of minutes, can I just give your Lordships some references? On the topic of criminal law, my Lord Burrows.
I'm very sorry to interrupt. I was just trying to get my head round your point that if you haven't got an entitlement when you are settling, you know you haven't got an entitlement when you're settling or entering into a compromise, you are thereby fraudulent, and therefore we're within the realm of fraudulent misrepresentation. I'm struggling with that because I would immediately be wanting to know in what sense is there a representation that's relied on by the other party to the contract.
Yes, my Lord, and if, of course, if there's no reliance, then the claim in fraud won't be made out, even bearing in mind the loose test for reliance that I think is Hayward and Zurich in the tort of deceit. But, my Lord, I think in answer to that question, can I simply refer your Lordship to 442 of Foskett Compromise, and no doubt your Lordships can get your hands on it, or we can provide you with a copy. But that's precisely how Sir David Foskett there articulates what happens when a claim is made that the person does not have any belief in. My Lords, on the topic of criminal law, just two brief points. The first is that I think it's said that the offence of blackmail need not be so circumscribed as it is in criminal law in civil law, because the consequences are different. And I think there's an implicit suggestion that the reason why blackmail is so confined as a crime is because of some criminal law aspect or mens rea aspect that is different in the law of contract. I just want to give your Lordships a reference to Smith, Hogan and Ormerod at pages 7412 to 7413 of the bundles, where the point is made that the reason why the offensive blackmail looks the way it does is because precisely the sort of debate that we have been having during this hearing has already been had in the criminal law of blackmail. And that's given rise to the phrase, the paradox of blackmail, that an unlawful action or a criminal action can result from two lawful acts. And what's happened in crime is that what has been called in the reference I gave your Lordships, a pragmatic solution has been arrived at, which is to narrowly confine the crime in the way that it's confined. And so there's absolutely every reason to read that across into the civil law context. My Lord, just finally on the US law position, I hope that your Lordships have been provided with a list of references that we prepared. Now, the purpose of this, Ukraine states in its written case that the general position in US law is that one doesn't need an unlawful threat. That's not correct. The general position in US law is that one needs an unlawful act, and it's regularly said that someone who does something which they have a legal right to do cannot be liable in duress. Now, in the time available, we've had to leave it to your lordships to look at the various states and what they've said about it, but that is what is borne out of those references. And the other point to make about the US law is that the restatements are dangerous. The Supreme Court has criticised them recently, and in particular the third restatement, which is what was relied on heavily by my learned friend, Mr. Thankey. And there is no substitute, unfortunately, for going back to the cases and determining what the cases say about what the law is. And if one does that, one arrives at the position I've set out. My Lords, I think I've overstayed my welcome, except to finish with a parochial point about Australian law, which is that my learned friend, Mr. Thankey, said that one shouldn't focus too much on Karam, the New South Wales Court of Appeal decision. I'd just give your lordships the reference to the High Court's decision in Thorne and Kennedy, paragraph 70, page 7590, where although His Honour Justice Nettle sets out some views of his own that might be said to favour lawful act duress, he notes that ever since Karam, which is 2005, that decision has by and large been followed without demur by all other Australian jurisdictions, with the exception of two cases, which are, of course, the front and centre of Ukraine's submissions. But those cases do not reflect the general position in Australian law. My Lords, unless there are any further questions, that's what I was proposing to say.
Oh, well, thank you very much indeed, Mr. Jones. Well, we return now to Mr. Shepherd for his reply on behalf of the appellant.
Lords, I'm grateful. Lords, the first point I make by way of reply is to pick up a point made by my Lord Reid, and that is that the relationship in question in this case was a long-term relationship between an airline principal who had nominated the appellant as their agent to sell tickets on behalf of the principal. That relationship was governed by standard term industry agreements, but it was a relationship where the appellant was reliant completely on the principal for the continuation of its business, because as Mr. Justice Warren found, it was a business devoted almost exclusively to the sale of tickets on PIA, which was the only carrier with direct flights between the United Kingdom and Pakistan, largely serving persons of Pakistani origin or heritage in the United Kingdom. The significance of that is that that is typically the sort of contract in which there is considerable reliance placed by, if I can call it, the weaker party upon the stronger. And it is typically the sort of contract in which it is easy to see why the law would imply duties of good faith, or at least would take into account the context of that relationship when looking at what the meaning of good faith is in the context of such a commercial arrangement. And my lords, that leads me to this point, that what all the cases seem to emphasize in relation to good faith is that it is a highly contextual doctrine, or it's a highly fact-sensitive analysis that has to be carried out in determining what the boundaries of good faith are. Now, my lord, for the purposes of my case, what I say is that the fact that this was the relationship of principal and agent, and it was a long-term contract under which the agent relied completely upon the principal for his income derived as a percentage of sales, then the primary obligation of the principal was to remunerate the agent for the work that the agent carried out on behalf of the principal. What was taken away from the agent in these circumstances, where the contract was terminated, but terminated only as a threat, it was terminated for one reason only, and that was, as Mr. Justice Warren found, as I'll show you in a moment, for the sole purpose of extinguishing the accrued claims for commission. Now, the second point I make is that if the respondents are correct, then the central point that would determine this appeal is the genuine belief in the claim or the demand that is made by the duressor. It puts front and center whether that genuine belief exists, and it would put into play in all such cases an analysis of whether that belief either was held and the basis upon which it was held. But of course, the Court of Appeal here went much further, and they made belief the subject matter not of any objective inquiry, but simply handed to the duressor the capacity to say that they genuinely believed whatever it was, no matter how unreasonably they did so. So my suspicion is that whatever approach this court takes to genuine belief, and whether it considers it relevant for the purposes of duress, the court will have to consider long and hard whether it is really appropriate that genuine belief should feature at all in duress. And Lords, the problem is really this. The problem is that genuine belief focuses entirely on the belief of the duressor. The reason that this is a problem is that it isn't just the duressor who enters into the contract. It is also the duressee. And this analysis focuses solely upon the belief of the duressor, whereas the contract is, of course, bilateral. It is also the duressee who enters into the contract, which on this basis is as a result of pressure imposed by the duressor. And the result is, in cases where duress is taken to have occurred, that the duressee has no choice to submit to the pressure. So it all comes down to whether the genuine belief of the duressor absolves the juressor from liability. On my learned friend's analysis, it does. That is not correct because, as I've said, it focuses solely upon the juressor and his state of mind. It leaves out of account any factual analysis or any independent analysis of the juressor's conduct, whereas the whole basis for the doctrine of duress existing is that the courts will not, ought not, to uphold contracts which are the result of pressure, because that offends the principle of autonomy and it offends the principle that contracts are supposed to be consensual. So that, we submit, is not just a theoretical objection, it's a very real objection because it leaves the discussion as one which is to be had between the court and the juressor. The juressee is a spectator in that question. He has no way of influencing the belief or not of the juressor. And as I say, if one adds the gloss of the juressor's belief, no matter how unreasonable, then one hands to the juressor all the power in a situation where the juressor has already exercised power to force another party to enter into a contract. But the next submission is that the only reason that the focus on the belief of the juressor is made is because they consider that genuine belief somehow makes the wrongdoing element in duress less wrong. In other words, they can have absolution for their sin if only they can persuade a judge that they believed that it wasn't a sin at all, even if objectively it was so. But as far as the coerced party is concerned, it makes no difference whatsoever, and it is something that the coerced party has no control over. My lords, next, the reason that my learned friend wanted to get away so quickly from the rationale for the doctrine is that the interests that the rationale protects are the autonomy principle and the voluntariness of the undertaking that a contract is supposed to enshrine. And that is all about the right of the juressee to enter into a contract without pressure. The law assumes, the common law assumes, and it bases its enforcement of contracts on freedom to enter into a contract and undertake obligations without pressure, which the law considers is undue or illegitimate. My lords, the problem with my learned friend's approach is that it eviscerates the rationale for duress, as stated by Lord Diplock in Universe Tankship. Indeed, it results in there being no doctrine to speak of at all. My lords, the court should think long and hard before allowing belief, genuine or otherwise, of the juressor to be the touchstone of relief. Let me give you two references. As far as the role of belief and good faith is concerned, see Professor Virgo's book on restitution at 3114, where he analyzes in particular the role of good faith. And, my lord, there is a convenient and handy summary of good faith. Perhaps we can just look at it quickly. At 1509, my lord, it's in a first instance decision of Mr. Justice Pepperell, where gathered together in one place are, I think, the most important quotations in relation to good faith. I'm not going to read it, my lords, but I just draw your attention to 1509 at paragraphs 138 through to the following page. My lords, this case is a perfect illustration of why, in practice, the focus on the belief of the duressor is so problematic. But what happened in this case is that none of the witnesses to whom the bad faith case could be put were called. And let me just take you to Mr. Justice Warren's judgment, which I probably didn't spend enough time on in opening. If you go to page 250, you'll see at paragraph 33, I also found striking the absence of evidence from certain individuals whom PIAC could have called. As will be seen, Mr. Shah might have been able to give helpful, at least to the court, evidence about what happened at the meeting on the 24th of September. My lord, that's the meeting when the agreement was signed with TT, or to say that no such meeting took place. It's reasonable to assume that this evidence would not have supported PIAC's case, otherwise surely it would have called him. The claimants did obtain a short witness statement from him, but in the end he was unwilling to come to court. I was told this was because he feared for his pension from PIAC. It was asked to provide a letter of assurance that he would suffer no adverse consequences if he did give evidence, but no such letter was forthcoming. The absence of Mr. Mellor was the country manager who orchestrated this scheme, is also inexplicable unless PIAC knew that his evidence would not support its case. PIAC have not called any of Mr. Mellor's or Mr. Shah's superiors or members of the APTA case committee. My lord, there was a committee formed by PIA to deal with this and other cases of agents claiming arrears of commission, as to which see paragraph 88 below. The evidence of such witnesses would have gone to the core of the allegations made by the claimants about the real reasons for putting pressure on the claimants in the way that is alleged. And my lord, across at paragraph 41, all this is, as counsel correctly submits, contrary to the overriding objective of dealing with cases justly. It's also conduct which I would not expect of the national flag carrier of a great and civilized nation. Further, this is not, as counsel again correctly submits, simply a matter of complaint. It has real consequences in the light of inferences to be drawn from the failure to call potentially irrelevant witnesses. So, my lord, that's what actually happened in this case. If you look at paragraph 164 on page 276,
I take it these were witnesses who weren't within this jurisdiction.
Oh, some were and some weren't. But of course,
the ones that were, you could have called yourself if you wanted to.
Yes, we did call one relevant witness ourselves, yes. Mr. Bijurani, who was the witness that we were able to get hold of. He was called and he gave evidence that the judge found both cogent and helpful. But of course, PIA is an airline and could have flown no end of witnesses from Pakistan had it wished to do so. And then at 164, the conclusion is, in the light of that statement, it's extraordinary to my mind that PIA did not see fit to call Mr. Mellor or to explain why it could not do so, if in fact it could not. Mr. Barber's evidence is put forward not as evidence of fact that Mr. Mellor said what he did to Mr. Barber, but rather as evidence of the truth of what Mr. Mellor said. Why, I ask, was the alleged maker of the alleged statement not put forward on such an important issue? One answer which immediately comes to mind is that Mr. Mellor would not, in fact, have supported what Mr. Barber said. So that was the technique, my lords. They sought to put in the witness box witnesses who were not witnesses to the events in question, but who were then used as the vehicles for putting forward hearsay evidence of what others are said to have said. So, my lords, in those circumstances, this case is an illustration of why the question of good faith and bad faith and the holding of genuine beliefs is so potentially problematic. And so it proved in the context of this case. My lords, the contractual arrangements are set out. I'll just give you, my lord, the references in paragraphs 13 to 18, pages 245 to 247. Let me say something about the claim to which PIA never had any defence at all, and in my submission knew they had no defence at all. The YQ claim, or the claim for commission on fuel surcharge. If you would turn to page 397. And what I'm showing you, my lords, is part of the pleadings. This is the PIA defence. And you'll see that at paragraph 44, the only defence that is put forward to the YQ claim is one thing and one thing only. You look at letter D, after a series of admissions, letter D, it's denied that the defendant is under any obligation to pay either the 9% commission on the YQ charge element of the tickets that they sold on behalf of the defendant, and what they rely on is the release in clause 6.2 of the new agreement, which of course was the clause which exonerated them from liability for any past, present or future commission. And that was the sum of their defence. And if you just look at one more document, if you go to page 27, I'm so sorry, if you go to page 401, this is in the reply of Times Travel, and you'll see at page 401, responding at 400, responding at paragraph 10 in relation to the YQ claim, what is pleaded at subletter E on page 401 was the previous decision of the Court of Appeal in a case that was relevant to deciding that very issue, Association of British Travel Agents and British Airways, in which the Court of Appeal addressed the same wording that now appeared in the same clause that was in issue here. And then at letter F, yet further the same issue in relation to whether fuel surcharges form part of the fare applicable within the meaning of paragraph 9.3.2 of Resolution 818G was decided by the Federal Court of Australia in Leone's Travel International and Qantas in 2009 against the plea now advanced. So not only did they not put forward a defence beyond the exonerating provisions of the new agreement, there were two Court of Appeal authorities that were flatly against the position they were advancing, and the decision of the Federal Court of Australia was on all fours exactly, with the same wording as between an agent and the national airline. So, my lords, where my learned friend refers to the fact that, draws attention to the fact that Master Leslie's decision post-dates the contract, in fact, there were decisions in 2000 and in 2009 that had established the position completely clearly. Nevertheless, PIA maintained the position that it did and refused to pay that which they must have known was their liability. My lords, PIA was in breach of contract right up to 2010. From 2011 and 2012, the breach of contract continued because they didn't pay the 9% commission that was owed. They knew that under the relevant agreements, in order to change the basis of commission, they had to serve the appropriate notices, and those notices had never been served. It was a simple matter, and if PIA had been in a position to say that the contracts had been appropriately varied by the service of notices, all they had to do was to produce the notices. But they didn't do so. Why not? Because they didn't exist. So they were in breach of the agreement at the date of the new agreement. My lords, the effect of the new agreement, if you go to page 605, my lords, this is a table that shows in the top half of the table just how much commission my clients had to give up. £1,271,649.88. That's what my clients were asked to give up. All of the conduct that follows is at a time when objectively the respondents are in breach of contract, and yet they force my clients to give up that claim on pain of being put out of business. To call what happened a compromise is simply wrong. What happens is that they serve a notice terminating the contract. Can I just take you to page 260? I'm so sorry, it's paragraph 260 at page 297. I apologize. Now, this is where Mr. Justice Warren says this: none of these facts are appealed. It's important to note the following matters. PIA considered wrongly, as I have held, but then the words much founded on by my learned friend. I have no reason to doubt PIAC genuinely believed to be true that the 9% basic commission had ceased to be payable, having been replaced by net sales remuneration in October 2010. The new agreement was in all material respects in precisely the same terms as the pre-existing arrangements, incorporating resolutions 818G and 824. One difference between the old arrangement and the new, and the only major difference, related to giving up the claimant's pre-existing claims to commission. 3, the new agreement was offered to the claimants in the very letter, that is to say, the notice, which gave notice of termination of the old agreement. There was, therefore, quite clearly no desire on the part of PIA that agents should in practice cease to be agents for PIA. What PIA wanted to achieve was simply an end to any claims by the claimants for their outstanding commission. the notice was in reality a threat, that unless the claimants gave up those claims, their agency would come to an end. It, of course, went beyond a mere threat, because if the claimants didn't sign the new agreement, their appointments would come to an end automatically on the expiry of the notice period. The claimants were given no opportunity to discuss the service of the notice. Some of the reasons which I have been given for service of the notice, in particular about financial risks, simply do not add up to scrutiny in relation to the claimants. The claimants' claims are all genuine and arguable. The YQ claim in respect of the period up to the 16th of October 2010 was very strong indeed in the light of the decisions of the Australian Court and Master Leslie, the Australian Court being, of course, in 2009. Had the summary judgment application proceeded, it would, in my view, have been bound to succeed. And then towards the foot of the page, he comes to the conclusion that although he rejected the overriding commission claim, it was part of the ABTA litigating agents, that's the 32 other agents who were also bringing proceedings, a claim in relation to which evidence may have been different. It would be wrong to say that the new agreement was made. There was no prospect of success of the ORC claim. And then over the page at 262, this is where the judge brings the threads together and applies the DSND factors, and at Roman 1 says the case concerning YQ, at least prior to 2010, was very strong. I feel confident that summary judgment would have been given. PIA ought to have paid 9% commission on the YQ element in respect of the periods prior to October 2010. There was a breach of contract in having failed to do so. No limitation point. 2, whether PIAC acted in good faith or bad faith is moot. The claimants have not established that there was bad faith, but nor has PIAC established good faith. So it is a rather more nuanced approach to good faith and bad faith. But then he says this: it is clear to me that the whole basis on which the notice was served and the terms of the new agreement were formulated was to ensure that agents would lose their claims to accrued rights in a situation where some of those rights, in particular the 9% commission on YQ, were clear. And then this: indeed, Mr. Sharma accepted that this was the motivation for the notice. Whether this demonstrates bad faith is a matter on which different minds might take different views. There's another reason, my lords, why bad faith and good faith are such difficult concepts to apply in commercial circumstances, in the case of commercial contracts. And then he says, I don't think it reflects well on PIAC that it should treat this particular agent, NT, in the way that it did when TT was successful, honest and reliable agent with a substantial period of loyal service, was given no adequate period of notice to allow it to adjust its business. It was not allowed even the short period of notice to acquire for cash its pre-existing ticket allocation. TT, in my judgment, had no practical alternative. TT protested at the time. And then one matter over which my learned friend glossed, and that was that during the period of notice, what PIA did was to cut the appellant's ticket allocation. And they did that by 80%. The claimants, the appellants were entitled to 300 tickets a fortnight. And what PIA did was to cut the ticket allocation to 60. If you look at page 279, at paragraph 180, you'll see that Ms. Justice Warren concludes, I'm unable to accept in the light of the above discussion that capping was intended to apply other than to agents who were declining to sign the new agreement. Nor am I prepared to accept that the reduction to 50% for agents not signing was driven by concerns about financial risk. In the light of all the evidence, it is at least as likely an explanation for the capping and 50% restriction that PIAC was intended to place as much pressure on the agents as possible, with a view to obtaining their signature to the new agreement. That was described by Mr. Justice Warren as pressure, which was designed for one reason only, and that was to force agents who had been served with a notice into a position where they would enter into the new agreement. So, my Lord, we say that if belief, genuine or otherwise, matters at all, then the fact that they were prepared to apply the pressure that they did demonstrates that there was an appreciation on the part of PIA that no agent in his right mind would enter into an agreement on the same terms as before, save only for giving up accrued claims to commission for tickets they'd already sold, which in my client's case meant kissing goodbye to £1.2 million. And there was no commercial justification for requiring them to do so. My Lords, in those circumstances, one looks at cases like Progress Bulk and Ting and asks oneself just how distinguishable is this case from Progress Bulk and Ting. The learned friend was at pains to say that those were cases where, it must have been perfectly obvious to the owners in Progress Bulk that they were in breach of contract because they'd let the ship elsewhere, having already committed to the charter. And Mr. Ting was a very bad man because he wasn't cooperating with the liquidators. The difficulty with that submission is that in the case of Mr. Ting, his actions and obligations to comply with the liquidators' demands did not require him to vote as a shareholder in a certain way. Looking at the case through the narrow lens proposed by the respondents is mistaken. He actually acted lawfully in refusing to vote if he had legitimately believed that he was entitled to the compromise he sought. Then on the respondent's case, there would have been no economic duress. And my Lords, that is the outcome for which my learned friend is contending. Mr. Ting's belief would have determined the case in his favour. And so in the case of Progress Bulk, the honest belief of the owners that what else could they do but offer a new ship and want to draw a line under the dispute by forcing charterers to enter into an agreement to give up any claims for damages, would have been determined by the owners' rather particular view of what they were entitled commercially to do. My Lord, I'm just going to pick up a few disparate points, if I may, seeing that we're approaching the 4 o'clock deadline, and with a view to shortening matters as much as possible. My Lord, just a word about consideration. Learned friend prayed in aid the decision in Simantob. I just give your Lordship this reference. Looking at paragraph 47, page 2119, the test for whether the forbearance was good consideration is if, one, the forbearing party's claim was one made on reasonable grounds, and two, which was in good faith believed by the forbearing party to have a fair chance of success. The test is contains an objective element, if the claim was not made on reasonable grounds, even if it was genuinely believed, it would not be good consideration. So limb A of Lord Justice Legate's test, no reasonable grounds for making the demand, would be consistent with Simantob, contrary to paragraph 55 of PIA's case and the submissions that counsel made to you. My Lord, as far as settlements are concerned, the PIA profess concern that unless the law is narrowly construed, no compromise will ever be secured. Well, Lord, that risk is overstated. First, on their own case, settlements and compromises can be reopened if there is a threat to breach of contract or a breach of contract has occurred, as both of these are unlawful acts. Many settlements occur after a breach of contract. Two, there was no consideration because the party did not believe its claim had a fair chance of success. Three, as set out in Simantob at paragraph 47, page 2119, the claim was not made on reasonable grounds regardless of belief. And secondly, the tests currently proposed set the bar very high and we say rightly so. However, should there be scope in law to deal with the settlement procured here, if that's what it can properly be called, the narrow threat might be legal. The demand was not justifiable. Notably, my learned friends spend no time in seeking to justify the demand. And his failure to do so should echo with your lordships, because there is no justification for the demand. And in a commercial situation, one would expect there to be readily apparent a justification which a party could put before you. Here, the only justification was that PIA didn't want to pay what they owed my clients. It fell within that exception of Lord Atkin that simply getting money was not a qualifying reason. Lords, I've just got...
Mr. Shepherd, can I just ask you, was there any evidence as to whether PIA were aware of the extent of TT's dependence on the continuation of their agency contract?
Yes, indeed, there was, my lord. And indeed, it is common ground for the purposes of this appeal. And Mr. Justice Warren found that without the PIA agency, my client's business would founder in a matter of weeks.
Yes, but is there somewhere where he found that PIA were aware of that?
My lord, my junior is just going through the judgment now, but I think that there is. Well, can I just make two rather disjointed points? First, the case of Smith and Charlick, which is at 2529, which the respondents rely on. Our submission is that that case would be decided differently today for this reason. That was a case where the wheat board and the plaintiff had entered into a contract. The contract price had been agreed. After the contract had been agreed, the wheat board purported to increase the contract price for the wheat. They demanded that unless the plaintiff agreed to pay an increased sum, they would refuse to supply him any further wheat. There was no legal entitlement to make the demand. The wheat board accepted that it had no legal claim to the increased sum, only what they described as a moral claim, see paragraph 2, page 2538. The plaintiff could not acquire wheat from anywhere else and so had to pay the increased sum. It was what would now be described as a no-choice situation. The case would be decided differently today by reference to progress bulk, because in that case, an unlawful act had been committed, see page 856, as here. And that was the case where, if effectively what was said, unless you waive the claims against you, we will not supply you with a ship at all. It was a take it or leave it situation. And the breach of contract was at the root of the problem. So, my lords, approached that case with care. My Lords, Dodd and Murphy, much founded upon the New Zealand case, Dodd and Murphy, it's a very limited assistance for the following reasons. First, it's a case where pressure did not cause Mr. Dodd to agree to a course of action. So it failed on causation. See page 2685. The decision to make the demanded payment was, as the court concluded, and I quote, a calculated and considered commercial decision made by Mr. Dodd after weighing the options available to him. That was not overturned on appeal. The pressure did not bring about an absence of practical choice, whereas absence of practical choice is conceded in this case. Secondly, that renders the subsequent discussion about whether pressure was illegitimate obiter, one would say, academic. Thirdly, it suggests that a test of a threat that is coupled with a demand which goes substantially beyond what is normal or legitimate would be difficult because of the range of normal bargaining positions. However, it is well accepted that the rough and tumble is part of the normal range of commercial bargaining positions. So that case is of limited assistance. However, Dold seems to fall into the same trap as Karam, which is the case which is founded on by my learned friend Mr. Jones on behalf of Russia, who assumes that the current terms and tests are vague and proposed an alternative test. There is a decision of the highest court in Australia called Thorne and Kennedy, where Justice of Appeal Nettle pours considerable, as we've identified in our case, pours considerable doubt on the correctness of the Karam approach. Lord, as we're coming to the we're beyond our time. Can I just make two final points? Lord, in relation to the American cases, Ukraine say that they could supply a similarly long list of US cases, which will apply a broader principle of illegitimacy. But ultimately, that is unlikely to assist the court. The point is that, as the restatements show, there is support for lawful act duress in US state laws, and in any event, as was shown to your lordships in court yesterday, the English courts and the Privy Council have firmly endorsed the principle of lawful act duress in English common law, and it is unlikely that your lordships would get any ultimate assistance from trawling through the US cases. My Lord, as far as Lord Burroughs' question about the tort of intimidation is concerned, and whether it required a threat to be of unlawful rather than illegitimate action, the premise of my Lord Burroughs' question was that the threat must be of unlawful action. That seems to be the better view, according to Mr. Justice Coleman's decision in Berezovsky and Abramovich in 187-191, but the Court of Appeal in Berezovsky left the issue open. My Lords, assuming that that is correct, the best answer seems to be that the point has arisen more than once in various guises, and that imposing a damages liability or criminal punishment is different, and in Professor Smith's language, a stronger response from avoiding a contract. See, for example, avoiding a contract for innocent misrepresentation versus requiring some culpability for damages. The point is neatly encapsulated by the passages from Lord Diplock in Universe Tank Ships that I took your lordships to yesterday. Lord, the second point was Lord Reed's interest in the language of unconscionability. and also the demand from a party in a situation of extreme vulnerability in Lord Justice Leggett's judgment in Al Nahyan at 187. The Lords, we don't read that as importing, and certainly not as importing wholesale reference to equitable standards. Rather, it is using unconscionability as a synonym or a cipher for minimum standards of acceptable behavior, but may come from earlier citation in cases like Crescendo, Hyton and Creamer, and Borelli and Ting at 183, which use this language, seemingly in this sense, but also without suggesting a radical amalgamation of the law of duress with equitable doctrines. My Lords, just, I think, two final points. On the suggestion that the work is done by the tort of deceit, my Lords, this is a bad point, because even if there is technically a representation as to the duress or state of mind, as much a fact as the state of his digestion, as was famously said, it is inherently unlikely that the victim relies on that representation, as opposed to acting on the pressure. There is a case, we haven't got it, my Lord, called the anemone, that makes the point in a slightly different context. My Lord, finally, Lord Bencher, Russia, made a number of points in relation to good faith, in particular my learned friend's 7 points. My Lord, whether there is a contractual duty of good faith is not at all the same as whether there are any restrictions on pre-contractual coercive behaviour that induce a contract. The two are simply not the same. And the rationale for their importation is radically different. The authorities about why they are or are not, or there are such general duties, do not seem particularly helpful to the issue in the narrow sense that applies in this appeal. But the premise seems to be that if there is no general duty to act in good faith, then they are where they've bound themselves to one another. It would be inconsistent to impose any restriction on contractual behaviour, where the parties enjoy greater freedom, it is said, on pre-contractual behaviour. But a duty to act in good faith in contractual performance would be of a different character. Taken to its logical conclusion, the point would be an argument as to why there should be no restrictions on pre-contractual behaviour, such as the doctrine of undue influence and so forth. My Lords, I think that I've come to the end of, I'm told that I've got. Yes, my Lord, I'm asked to draw your attention to a case called Clipper Maritime and Shellstar. That is the anemone. We'll supply it in due course as soon as we can. It's 1987, 1 Lloyd's Report 546. And there, Mr. Justice Staunton, as he then was, said the notion of reliance on a representation as to state of mind is artificial in the real world. We'll supply that in due course. Lord, I was just finally, the reference that your Lordship was, Lord Reid was looking for, is page 267, paragraph 121, Roman 4. Lord, unless I can assist with any other matter, those are my submissions on behalf of the appellant.
Yes, this is this is put shortly a finding that TT was economically dependent on the continuation of the agency. It doesn't say anything about Hayek's knowledge of that.
My Lord, that's the best that we've been able to find.
Yeah, okay. Right, thank you very much. Well, we're very grateful to all counsel. This is obviously a case of considerable importance. We'll now take time to consider our judgment. The court will adjourn.